Okay, well, good afternoon, everyone. On behalf of the Goldstone Caregiver Center and also the Faith Community Nurse Program, I welcome all of you to today's presentation, Protect Yourself with Trust, How to Protect Assets, Avoid Probate, and Maintain Control. I'd like to introduce to you our presenters today, Danbury attorneys Tom and Michele Murphy. They are elder law, estate planning, and probate attorneys serving the Danbury area for over 50 years combined. Attorney Thomas E. Murphy received his Bachelor of Science in Economics from the Wharton School of the University of Pennsylvania, followed by a career in corporate management. He then graduated cum laude from Pace University School of Law. He is a member of the National Academy of Elder Law Attorneys, as well as the Elder Law section and the Estates and Probate section of the Connecticut Bar Association. Tom is an accredited attorney with Veterans Affairs. Attorney Michele F. Murphy, who's an RN and MSN, earned her Bachelor of Science in Nursing from the University of Pennsylvania and her Master of Science in Nursing from Yale University. She practiced as a newborn ICU nurse at Yale New Haven Hospital and Danbury Hospital, and as a community health nurse in Western Connecticut. Michele earned her Juris Doctor from Pace University School of Law and has been practicing elder law, estate planning, and probate law ever since, including advocacy for the rights of mentally and physically disabled persons from the probate courts to the Connecticut Supreme Court. Michele also is an accredited attorney with Veteran Affairs. During our next hour together, you'll discover how Tom and Michele have uniquely merged their educational and career experiences in business and nursing by applying a holistic problem-solving approach to elder law and estate planning issues. Their approach has enabled them to provide comprehensive assessments and plans individually tailored to meet their clients' needs. So with that, I'd like to turn it over to Tom and Michele. I want to thank you all for being here today.
Good afternoon, everyone. Thank you so much for joining us. My name is Michele Murphy.
And I'm Tom.
Which I think you figured that out probably. And we're so glad that you're able to join us, and we so appreciate this opportunity that Goldstone Faith Community Nursing have provided us to have a chance to talk about. I know on the edge of your seats now, and how you protect yourself with trusts. A lot of people historically have thought that trusts are for the rich and famous. I certainly hope that all of you who are joining today are. But for those of you who aren't, trusts you may find to be very helpful. Now, before we get into talking about trusts, I just want to make sure everyone's gotten an outline that Miranda would have emailed all of you within the invitation. So hopefully you have that. If not, it should be as an attachment from that email. So if you just wanted to take a second, if you don't have it, it might help frame some of the things that we're going to be talking about today. The outline will actually cover a lot more than what we are going to talk about over the next hour, but it has one spot for you to have a lot of information. So I hope you can follow along with us. So as I just mentioned, trusts can potentially be for anyone. And the next hour, we're going to talk about how. We like to think about the use of trusts in all kinds of areas. And a lot of people are surprised to hear something in which you can use trusts. You can use trusts to protect assets from Medicaid and VA aid and attendance program. You can also use trusts to use like maintain control, minimize estate taxes. That's a big one for a lot of people. Preserve IRA and 401k funds. Provide for disabled family members. Provide for pets. Yes, Fido has a chance. Protect your estate from your children's creditors. And that is why we say plan and protect. So people are surprised that trusts can provide so much diversity to satisfy so many needs. So let's talk about some of the ways in which trusts can be used. One of our classic favorite example, I think someone might have their their audio on. Is everyone?
Yeah, other than Michelle and Tom, if any of you if all of you can please put yourselves on mute, that will be great. Thank you.
Great, thanks so much, everyone. So one of our favorite examples that we like to share with others of trusts is our client, Helen. Well, Helen decided that she wanted to try and figure out a way to streamline her estate plan. And she has a daughter and she has a son. She made them both power of attorneys to handle her affairs, but her daughter was the one primarily taking care of bills. So when Helen started to need some home care, Helen's daughter was the one paying the bills out of Helen's bank accounts. I guess I should go backwards. I think I was a little confusing there. So Helen's children, what she did was, instead of making both of them power of attorney, she made Helen's son on some of her bank accounts as joint owner, and she made Helen's daughter joint owners on the other bank accounts. But Helen's daughter was the one that was her power of attorney. Her son was the standby or successor. So when Helen started needing home care, her daughter was paying her bills just like all of the bills. And I can imagine what Helen's daughter was thinking, because we heard this story from Helen about how the daughter was handling which bank accounts she was going to pay for Helen's home care. So what was the situation with Helen, Tom?
So the situation with Helen is that she was trying a do-it-yourself probate avoidance. Now, avoiding probate is a very common topic. We have a lot of inquiries from people who are interested in avoiding probate. So let me say a few words about that, first of all. Probate is what most people go through. There's nothing terrible about it. If you have a will, your will has to be probated before anything can be distributed to anybody. But it is a more time-consuming and a more cumbersome and a more expensive distribution or administration of your estate than some of the alternatives. It can take close to a year, it usually does. There are multiple filings that have to be made in the probate court. Each one takes a certain number of man hours to produce. And of course, there's a cost associated with preparing each one. And so when you put it all together, probate takes a long time. It takes many, many hours of work, and it does cost quite a bit of money to do. So a lot of people are interested in exploring the alternatives. Helen's alternative was a do-it-yourself approach. She held her bank accounts jointly with her children. And that's fine, that sounds good, it's simple, and you don't have to pay a lawyer to do it. And everybody loves to save money on legal fees. So why not? Well, this is an example of maybe why not. In this case, Helen's daughter used the bank accounts that Helen owned jointly with her son to pay for Helen's long-term care. And so upon Helen's death, the only accounts that were left were the ones that were jointly owned with the daughter. And so Helen intended to leave her estate in equal shares to her two children, but it didn't work out that way. And there are other forms of do-it-yourself planning that can also not work out the way you intend. And so what we recommend is that you have a plan that can't be messed with by others when you're no longer able to manage your affairs yourself. And that is best done through a revocable living trust. Now, you've heard of revocable living trusts. You've received all kinds of ads bombarding you with information about revocable living trusts. You have friends and relatives with revocable living trusts, and with good reason. They're very popular because they do avoid probate, but they do it in a way that leaves you in control of the process. The trust agreement that you sign is very much like a will. It contains all of the provisions as far as who gets what and who does what if you're no longer able to manage it yourself. So you put your assets in the trust, you're the trustee. And so really, while you're alive, you've given your assets to yourself as trustee of your trust. If you own a home, we do a deed from you to yourself as trustee. You retitle your bank accounts in your name as trustee so that your trust owns everything that you own. And then for the rest of your life, it's as though nothing has happened. You file the same tax returns, all the income is the same tax rates, because the trust is a see-through. It doesn't have to file its own tax return. Really, nothing changes as long as you're alive. But then upon your death, the trust provides for the distribution that you intended. And along the way, no one has been able to interfere with your wishes or subvert your plan. And so for that reason, it's gotten very popular.
Absolutely. And I'm sure if any of you are, was it? Oh, Susie Orman. Every time her financial show that she would have on the network, it was always get a revocable living trust. Mm-hmm. So we would always think.
Oh, by the way, that's a good segue to the point of whether or not you should trust internet documents. And our feeling, and that of most practitioners, is that you should not, because they are published by national publishers, whereas the laws differ from state to state and from time to time. We now have a new uniform trust law in the state of Connecticut, and there are other changes to the statutes and the case law that occur from time to time. And so there's really no substitute for a practitioner in your state who is schooled and experienced in these matters.
Absolutely. Good point. We have a client actually. Her name is Carol. She has a mentally disabled daughter, and the daughter lives with Carol right now. And she knows that her daughter, whose name is Chloe, can't live alone without Carol. Now, Chloe receives Social Security through SSI because she never worked, and she gets Medicaid. And so Chloe also has a sister. So Carol's other daughter doesn't have any health issues and is not disabled. So when Carol came to meet with us, she thought, okay, I have a great idea. I want to leave my whole estate to Chloe's sister, to my other daughter. That way, she'll be able to monitor and manage that half of the estate that I want her to hold for Chloe. Good idea?
Well, again, it's one of those things that sounds simple and streamlined at the outset, but can be complicated later on. Remember that your estate plan is not intended to be viable and effective only during the term of your life, but also in many cases during the term of your children's lives. So if you have a situation where assets need to be held and used for one family member with some restrictions, and that was the case for Carol, then you also need to think about what's going to happen to both of your children long after you're gone. Because if you leave everything to one daughter and ask her to take care of your other daughter, well, what happens if the one daughter is not able to, or simply changes her mind, or her husband changes her mind for her, or she has a creditor who changes her mind for her? So let's say that the one daughter goes through a divorce, and we have a 50% divorce rate in this country. So how do you not plan for that? Or a lawsuit, or any other type of creditor. Maybe she has a medical problem. Maybe as your children age, the so-called healthy daughter becomes not so healthy in her later years. And now she's simply prevented from sharing the money that you intended for Chloe with Chloe. She just can't do it. And so now, once again, your plan has been ruined. We're talking about paragraphs C and D on the first page of the outline. These are both forms of third-party trusts. In other words, your money being held for a third party, usually a child, although it could be any family member. And these come in two forms. One is a support trust, and the other is a special needs trust. The support trust is if you have a child who is simply not good with handling money. Maybe she's a spendthrift. Maybe she just has poor judgment, no impulse control, who knows what. and she's just not a good candidate to be receiving half of your estate. Maybe she has a rocky marriage, and you know during your lifetime that she might be at risk for divorce or medical problems or whatever. And so it could be a good idea to have a trust for her that will hold the funds during her lifetime, long after you're gone. Or let's say that your daughter is really special needs. She's on public assistance, she has some form of disability, and if you leave half your estate to her, it's going to throw her off of those public benefits. And the legacy that you leave her will be consumed paying for things that the state and federal government should have paid for and would have paid for. So instead, you want to leave that in the form of a trust that's fairly restrictive and simply doesn't allow distributions to the child for anything that the state or federal government would have paid for instead. And so with those two types of third-party trusts, you can tailor the needs of your children into your estate plan so that you have left your estate in a way that is most targeted to the needs of that child and is safe and secure so that, once again, no one can mess with it when you're no longer able to control it. And that type of trust can be a standalone document, or it can be written into your will. If it is, though, it'll remain subject to probate court jurisdiction for the life of your child, which involves accountings and fees and so forth. Or you can write it into your revocable living trust. And a lot of people feel like if they have a need for one of these types of trust, they might as well do a revocable living trust anyway, because you're sort of halfway there. And so that way you get the probate avoidance and you get the management of the funds for the family member without it being subject to the probate court for the child's lifetime.
And just to add to that, we've seen all kinds of situations where it's not necessarily a parent to a child. It could be a grandparent that has a child that has a disability, whether, before they were reaching the age of majority at age 18 or afterwards. We've actually even seen situations where siblings have left. We had a situation where the sister had quite a bit of assets and her husband was gone and she didn't have children. And her brother, who was not in the best of health, she wanted to plan if she passed away before him. And he was on public assistance for his long-term care needs. So it's interesting how special needs and support trusts can be used. They're very flexible and it's very powerful, like Tom said, because they don't have a situation where it will interfere with that, that distribution will interfere with what they already can have covered through public benefits like healthcare and housing and what have you. So pretty powerful use of trust. Now, one of the trusts that we've seen being used a lot recently, and it's something that a lot of people don't know that even exists, has to do with retirement funds. Now, a lot of people aren't so much getting the pension anymore and planning that for retirement income. Some people are fortunate, but many aren't. They are saving for retirement through IRA 401k funds, either through their employer or their own means, and have a lot of assets in the retirement funds. And that's what happened with our clients, Charles and Kathy. A majority of their assets were in 401k funds. And they came to us saying, well, it's the concern, you're going to kind of hear this throughout our talking today. We really, really want our children to receive the maximum benefit of our 401k funds after our death. However, life happens. People do unfortunately have marriages that fail. They have a car accident, there's a lawsuit. I know this sounds so depressing, but life is the reality of life. I mean, who would have guessed this past year would have happened the way it did? And people are now concerned about, well, what happens with my retirement benefits? I've been contributing to these, or my employer has for years, and it's grown to a point where it's giving us security now. So their concern was, how can they control the distribution of our retirement funds after we pass away to our children. And how was that responded to for Charles and Kathy?
The issue here, of course, is that any of us as parents would love to make sure that the legacy we leave behind is used for our children's benefit only. We don't want to see any of it go to creditors or anybody else. And so there's a natural temptation to want to leave our estate to our children with strings attached, leave it all in the form of a trust. And yet most of us don't. Wealthy people do, because for tax reasons, they really have to. But for most of us, that's not the issue. So most of us don't leave our estates in a trust for our children. And I think it's because most of us just don't want to be remembered as control freaks. But retirement plan accounts are different because of a couple of things. Number one, increasingly, they represent a larger and larger percentage of our estates. That's just a simple reality in the modern world. Very few people get pensions now. Most of us are accumulating assets in our retirement plans. And for a lot of us, their value greatly exceeds the equity in our own homes, and they've become our most valuable assets. So they deserve special attention. But the more important issue is that your children aren't going to think of those accounts as available assets any more than you and I do. We think of them as an income stream, don't we? For tax reasons. Because when we retire, we could cash out all of our retirement accounts, but we won't, because we don't want to have all that income in one year. We want to spread out the taxable income as long as possible. And when we die, our children will want the same thing. They're not going to cash them out to go buy a vacation house or a yacht. Probably. They're going to take the required minimum distributions, RMDs, every year, the same as we will. Or now under the Secure Act, they'll draw everything out over a 10-year period. That was lifetime up until last year. Maybe it'll go back to that someday, who knows? But the point is there's a payout period, and they will stagger it over that period. That creates an opportunity to protect it. That creates an opportunity to have strings attached, because it doesn't matter to the child. They're not intending to liquidate it all at once. And so the way in the outline, I've called it IRA beneficiary trust. Think of it as a retirement plan trust, because it can also accommodate 401ks and 403bs and so forth. But the way it works is you would continue to own your retirement accounts for as long as you're alive. If you're married, you would continue to name your spouse as the primary beneficiary. So upon your death, they would pay out to your spouse, and then your spouse would continue to own them for his or her life. But then upon the second of your deaths, the accounts would be paid to the contingent beneficiary, who would be the trust instead of your children. And so upon the second death, the accounts get paid to the trust, and the RMDs go every year to the trust, and the trust distributes them immediately to your children in equal shares, or whatever percentages you want. And the child can also request more if he or she wants to. So far, nothing has changed. The child gets everything he or she otherwise would get, and the ability to get whatever he or she wants. The difference is, let's say that one of your children ends up with a problem, divorce, lawsuit, illness, whatever, then he or she can tell the trustee, hold off, no more distributions for now. I have a problem, and I'll let you know when the coast is clear. So then the trust accumulates the payments that are coming its way and distributes them to the child whenever the child turns distributions back on. And there's no change in the taxation of the account, so there's no downside to doing this. It simply provides a way for your retirement accounts to do what you want them to do, which is to benefit your children no matter what.
And what's interesting is that it's become so increasingly popular because of the fact that, and we're assuming it's because most people's assets are in form of a retirement plan. But one thing to understand, though, is that it's not the child or whoever is the beneficiary that owns the retirement account. It's the trust. And that's what provides some insulation from them, from creditors, and they're applying for financial aid for college or what have you. So that's a pretty nifty way to protect your retirement funds for your children's situation. One other trust, and I mentioned it when I was listing the different ways that trusts are used, is a pet trust. And it's not something that we see that often, but we do see it from time to time because, as we know, it's not just man's best friend, a dog or a cat, but it could be somebody who has a very expensive animal or some animal that's very beloved. And we like to mention that people can set a trust up for that type of situation. We've had people come in who have birds. Birds can live for decades. And we've had obviously people with other kinds of pets, horses, and actually, a dog that was bred or just a beloved dog. And the way it works is that you can also set that trust up within your will or a standalone trust, and it can set up the same way that Tom's been talking about the other trust, which is that there would be a designated trustee, meaning somebody who would be taking care of the animal. And there would also be funds set aside for vet bills and, food and shelter and whatever have the plan, especially something like a bird that will outlive all of us. Someone may be really interested in having that plan set forth. It just gives a lot of peace of mind. So we like to mention that. It does make most people sort of snicker a little bit that there's such a thing called a pet trust, but it's actually legitimate. And if that's something that fits your plan, then certainly consider that as an option. Moving on into irrevocable trusts, probably one of the hottest topics these days that we're seeing. Our clients, Jack and Patty, exemplify the concerns that a lot of people have, and that has to do with affording the cost of long-term care. And we all know that that can be catastrophic and how to plan regarding that. Our last lecture that Miranda had mentioned discussed more in detail about ways to protect and consider asset protection techniques. This being probably one of the most popular ways. And so when Jack and Patty came to see us, they were fine and healthy. They had no pre-existing conditions that would consider or warrant any planning per se. However, I say that we all know, like this past year has happened, and who would know what the long-term effects from COVID and what we have down the pipe for sure. But their concern was they had children, they wanted to protect their assets because they didn't want it gobbled up in long-term care. They have been saving, whether it's, through all sorts of means from, having their house increase in value and their bank accounts as well. But their concern was because of the Medicaid 5-year look-back period, they wanted to plan ahead. And we'll get into discussing that as well. Their concern was, like we've expressed this past little while, is if we give our assets to our children outright, how do we protect those assets from life being uncertain for our children? How do we know that money's going to be there when we might need it to pay for our care? And so what were the options for Jack and Patty because of their concerns?
So the issue here, of course, is that the cost of long-term care has become the largest potential cost item standing between you and your own net worth and later on your children. It used to be that estate taxes occupied that distinction, but no longer. Long-term care, if you need home care, that can cost up to $80,000 or $100,000 a year. And if you need nursing home care, it's closer to $200,000 a year. So if you're in that boat, it doesn't take long before your estate can be either gutted or severely diminished. And if you're married, then the question is, well, what then happens to your spouse? If a lot of your money is used up on paying for long-term care for one of you. And for any of you who are near retirement age, this is relevant to yourself. And for any of you who are younger, this probably is relevant to your parents who may be in their retirement years. With that cost out there, what can you do? Now, obviously, we recommend long-term care insurance for anyone who is so inclined and can afford it and so forth. But most of the people we meet don't have long-term care insurance to the point that it fully covers the cost of long-term care. Unless you have a daily benefit of $500 with a lifetime benefit term, then your assets are still exposed to some degree. The insurance will pay for some, but you will pay for some, and therefore you'll see your estate diminish over time. And so a lot of people who don't have really great insurance or don't want to pay for it, thousands of dollars a year every renewal, a lot of people then set their sights on trying to qualify for state assistance, Medicaid, Title 19, to cover that cost down the road. And of course, the last thing you want to do is see your estate totally depleted before getting that relief. So some people will say, I know, I'm going to put certain assets in my children's names so that after that dreaded 5-year look-back period, those assets are protected and the state can't get them. Well, of course, if you put something directly into your children's names, they own it. And once they own it, you have no control whatsoever over what happens to it. If you want it back, or you want a portion of it back, your children can simply change their minds, or their spouses can change their minds, or if they have a creditor problem like a divorce or a lawsuit or their own illness, then their creditor will prevent returning those funds to you. And so in these situations, for people who are interested in an asset protection combined with probate avoidance, then they are candidates for the Irrevocable Asset Protection Trust. And the way this works is you sign a trust agreement that looks a lot like the Revocable Trust, except it has to name someone other than you as the trustee. So let's say you name one or two of your kids as trustees, and then you put whatever assets you want into the trust, either right away or over time. You can feed it whatever you want, whenever you want. And anything that you put into the trust is protected after 5 years. And for the rest of your life, those assets will sit there in that trust and be protected not only from the state, but also from your children's creditors. So no matter what happens to them, they don't quite own whatever's in the trust. It's this nice little bubble between you and your children. Your creditors can't get it, their creditors can't, even if they're trustee. So if you want something back from the trust includes a back door in which your children as trustees can make distributions to themselves and then cut a check back to you. We'll talk about taxes in a minute. So you want something back from the trust, they cut a check from the trust to them, put it in their account, and then they cut a check from their account back to you. You have a veto power over all distributions. So if your children simply want to take your money, they can't. They have to give you written notice of all intended distributions, and you can veto any ones that you don't want them to make. And then upon your death, the trust distributes according to whatever plan you have in mind. It's written into the trust. And you also have the power to remove a trustee. So you have control over whatever is going on in that trust. Whereas if you put any assets directly into your children's names, you will not have any control at all.
Pretty nifty. Mm-hmm. So one question that you may be having, and this is what went on with our client, Anna, she wasn't at all concerned with what Jack and Patty were concerned with. Jack and Patty were concerned with giving things outright to her children. Anna was all set. She was fine to give her kids her assets. Her assets, though, consisted of a house and highly appreciated stocks. So when she came to see us, Anna's concern had to do with what happens if these assets, my home and my stocks, get sold after my death. Are they going to be hammered with capital gains tax? So Anna's concern was a little different than Jack and Patty's, but nonetheless, one that you might have thought of.
Mm-hmm. So there are 3 taxes to be concerned with, and the trust provides benefits for all 3: capital gains tax, income tax, and gift tax. If you were to die today, then your capital assets, your house, any stocks that you might own, would pass to your children with a stepped up cost basis equal to your date of death fair market value. And if your children liquidate those assets, they pay no capital gains tax on your lifetime gain. Also, if you sell your house because you want to downsize at some point, then you get the capital gains exclusion on the sale of a primary residence. If you put your assets in your children's names, however, you also give them your cost basis, which means if you sell your primary residence, you will not get the capital gains exclusion and you will pay capital gains tax. Or upon your death, the assets will not pass to your children with a stepped up basis, which means they will pay capital gains tax. The trust is written as a so-called Grantor Trust, which means that even though the trust property, whatever you put in it, has been taken out of your name for all other purposes, it's still considered to be yours for tax purposes. That may sound bad, but it's actually very good, because that means that you still own the cost basis in that property. And so if you sell it during your lifetime, the capital gains will be treated the same as if you had continued owning it. So you'll still get the exclusion on the sale of a primary residence. And any assets that you don't sell during your lifetime will still get the stepped up basis at death, which means your children won't pay capital gains tax. Also, regarding income taxes, if you put assets in your children's name and those assets throw off interest or dividends, or let's say there's a rental property or something like that, all forms of income would be taxable to them. If they own the assets, they own the income. But the trust, once again, being a grantor trust, requires that all trust income end up being included on your 1040, which means you're paying the income tax. And that's good and fair. It also means that you will not be paying income taxes on the trust. So nothing will be taxed at trust income tax rates, which are truly abusive. So you want that income on your 1040. It's the best place for it to be. And because the trust is a grantor trust, that's where it will be. The third is gift taxes. If you put assets in your children's names, you've made a gift. If that exceeds $15,000 per person per year, you have to file a return. However, if you transfer the assets into the irrevocable trust, then again, because it's a grantor trust, you have not made a gift legally, because you're still considered to be the owner of the trust property for tax purposes. It's as though you gave it to yourself. So there's no gift tax return to file. If the trust distributes money to children so that they can then give it back to you, then the gift tax return has to be filed if it exceeds $15,000 per person per year, but usually it doesn't. And then even if it exceeds that amount, you then have a $7.1 million lifetime gift tax exclusion. So even though you might have to file a return, you're not going to pay any tax.
Pretty cool.
Yep.
One thing to add about the irrevocable trust is that most people think about it not so much that they are protecting assets for their next generation or whoever it is that they're leaving it to. Think about it as having your cake and eating it too. Because when you put money into, when you put your assets into an irrevocable trust, what you're really doing is protecting those assets, hopefully for you. And we like to emphasize that because, excuse me, a lot of people think that they're looking to have a way to give that asset away. Well, not necessarily. I'll give you an example. When you have a situation where you might need home care, and the home care that can get covered by the state of Connecticut, and we're going to talk a few minutes about how Medicaid works once you're receiving benefits from the state of Connecticut. They will cover up to a live-in home care. But let's say you have a medical need that really requires someone being awake at night, and you need funds to be able to supplement that home care that Medicaid is paying for, to provide and enable you to have the lifestyle that you wish. Well, if you have a trust that you have put money into, an irrevocable trust, so it's safe from being able to be looked at, for Medicaid purposes, those funds are available to pay for that extra care. Versus if you liquidated all of your funds to qualify for Medicaid, none of those funds will be available. Another example would be that you want to live at home or in assisted living, something that you might choose, but the state of Connecticut won't pay enough to be able to cover things at home, like a new furnace, a new roof, a ramp to be put in, a bathroom modification to enable you to stay at home and live as independently as possible. Those are things that the trust can pay for. And that is why that we suggest considering the irrevocable trust to enable you to have the lifestyle that you wish versus having to not have the funds available. So right. We like to make sure that people understand that the irrevocable trust provides that win-win, that having your cake, which is to be able to enable you to qualify for government benefits to cover for long-term care, as well as having the funds available to cover what it is you need to live the lifestyle that you wish.
Right, because the last thing you want is to financially paint yourself into a nursing home. What we're seeing, for our elderly clients, they are favoring the irrevocable trust over the revocable, hands down, because they both avoid probate, and the elderly clients want to get the asset protection too, because the older we get, the more we get concerned about the cost of long-term care. What we're finding, though, is that a lot of clients in their 50s and 60s are starting to think very seriously about the cost of long-term care, and they're starting to do the irrevocable trust along with the revocable, because someone in their 50s or 60s, you're not going to put most of your assets into an irrevocable trust, but you want probate avoidance. So you do the revocable, put some assets into that, do the irrevocable, maybe start putting some assets into that. And then over time, you can kind of shift from one to the other as you get older and as you start thinking more about the cost of long-term care. And so the two very much work hand in hand in parallel over the rest of your lives.
Good point. To really understand how the irrevocable trust, you really need to understand the way Medicaid works. And we went into a lot more detail over Medicaid and exemptions and exceptions for Medicaid in our prior program. So please feel free to take a look at that. But to understand how it interrelates to trusts, it's probably a good idea if we review just some basic information regarding Medicaid. So I always like to tell people the most important housekeeping issue of Medicaid is what it is and what it isn't. Now, Medicaid is not Medicare. The reason that we have to distinguish that is a lot of people say, oh, I don't need to worry, I have Medicare. Well, the reason that's important is that Medicare is a short-term, it's not something that you can count on paying for long-term care. What do I mean by that? Well, we know that Medicare can be used to cover going to the doctor. It can be used going to the hospital. Yes, it's true. It can be used to cover up to 100 days of skilled nursing care. If you go to the hospital for a stroke and need rehab, or some kind of fracture and you need rehab, it's true. You can go to a nursing home for up, not assumed, but it can be up to 100 days. Well, a lot of folks, unfortunately, need more than 100 days of coverage, whether it is they go home after they're in the hospital and they need a visiting nurse. Well, Medicare doesn't cover when you have non-medical home care coming into your home. What's non-medical home care? Someone who helps you with your activities of daily living, getting your meals prepared, getting you in and out of the shower or tub, making sure that you are getting as independent as possible. And Medicare doesn't cover that. So we need to distinguish that. The other thing is, what is Medicaid? Well, it is also Title 19. So if you hear the term Title 19 and Medicaid, they are one and the same. The Department of Social Service through the state of Connecticut is the agency that administers Medicaid or Title 19 benefits. So you may have heard of DSS. That is the agency that does so. Tom's going to go over the financial criteria for Title 19 or Medicaid so that you have a deeper understanding of that. And then we'll get into a couple of situations to better exemplify how Medicaid and irrevocable trusts can work.
So I think most people know that in order to be eligible for Medicaid, you have to be pretty close to broke. It's a very harsh program to qualify for. You're allowed to have up to $1,600 in the bank. You can also own a car. You can also own a prepaid funeral contract. You can also own your home. Your home is an exempt asset as long as either you or your spouse are living in it. The issue is that the house can become an exposed asset down the road, even if it is an exempt asset in the short term. So if you're living at home and you're getting home care and you want to qualify for Medicaid to pay for it, the house is exempt. But if you move into a nursing home later in life, the house may stay exempt if your spouse is living in it. But later in life, if one of you has passed away and the other one of you moves into a nursing home, then the house loses its exemption. It has to be sold and the proceeds have to be consumed. Also, even if you live in the house for life and you never enter a nursing home, then upon your death, that house has to be probated and the state of Connecticut will recover from your probate estate for everything they've paid out for you during your entire lifetime. And so the house, some people will not include the house in their protection planning if they really have an urgent need for Medicaid, because it can take time to protect assets. And so what they'll do is they'll focus on the assets that are currently exposed and try to protect those and hope for the best on the house. But for someone who's currently healthy and thinks that they have at least a 5-year horizon ahead of them of good health, then they often do include the house in their planning, because if the house could potentially become exposed down the road, then why not include it in the planning? If you are married and if you have liquid assets, then the healthy spouse can keep up to 1/2 of the liquid assets up to a cap of $130,000. So if you have a house plus $100,000, your spouse can keep 50 and you have to spend down the other 50. If you have a house plus 500,000, then the spouse can keep the house plus 130,000, not 250. So in that case, 370,000 would have to be spent down before qualifying for Medicaid. With regard to income, if you're in a nursing home, most of your income goes to the nursing home. If you're married, some of your income will go to your spouse and some of it will go to the nursing home. And your spouse's income will not be counted at all. If you're living at home, then your spouse's income is off the table and your income is off the table as long as it's below $2,300 a month. If it's over that, you're not eligible for Medicaid home care, subject to something we'll talk about in a few minutes. And it has to be true that prior to your Medicaid application, during the 5 years prior to it, that you haven't transferred any assets out of your name.
And that leads us to our situation with many clients. Our client Marguerite was an example of probably many clients that we have. She came to us. She was already receiving just a little bit of home care. I think it was a couple hours a week, 3 times a week. So not anything serious, just to help her with some of the things that she was having some difficulty. Now, she had $300,000 in her name, and she wanted to get that out of her name through an irrevocable trust. So here is the probably $1 million question. So she needs home care. She has money she wants to transfer to her kids. She knows all about transferring outright. She's interested in using the irrevocable trust, but says, oh no, what about the 5-year look back period? What do I do?
For someone who's in good health, then transferring assets to the irrevocable trust is no problem as long as you have 5 years of good health ahead of you. But the question is, what if you don't? So if someone applies for Medicaid less than 5 years after they've transferred assets, the state, of course, will see that that transfer has occurred. But the big question is, what do they do to you? And the answer is not what most people think. Most people think that if you transferred any assets at all within 5 years of your Medicaid application, the state won't give you Medicaid for 5 years, so you're going to have to get that money back somehow. That is not true. What is true is that the state will disqualify you for Medicaid for a calculated penalty period, which is 1 month for every $13,500 transferred. Think of it as roughly 7 months for every 100,000. So in this example, where there was 300,000 on the table, that would not lead to a 5-year disqualification period. That would lead only to a 21-month penalty period. Now, suddenly that's not so bad, because a lot of people, if they're in the early stages of needing long-term care, maybe they're getting some home care, maybe it's not too expensive. So even after they start needing care, they have the opportunity to transfer assets into the irrevocable trust and wait out the penalty period before going on Medicaid. And some of the money will have to be spent on home care during that time, but most of it won't. So that at the end of that 21-month penalty period, most of it would be left. Now, what if someone's already in a nursing home or their cost of home care really is high? Is it true that they shouldn't bother because all the money will have to be spent on their care during the penalty period anyway? And the answer is no, there's still an opportunity. Because what we do in those cases is we calculate, using a little algebra, the percentage of assets that can be put into the trust resulting in a penalty period, and the percentage that can be put into an immediate annuity that will be structured to pay for the cost of care exactly during that penalty period. So that when the penalty period is over, the annuity is over. Think of 2 lines converging. They both end on the same date, and then you're eligible for Medicaid. So if we know that a certain portion of your assets are going to have to be taken out of the trust over time to pay for your care during the Medicaid penalty period, then you don't put everything into the trust, because that would overshoot the amount that could actually be protected. What we do is we initially and have the client purchase an annuity that pays for their care only until that time, because that results in a higher percentage being kept in the trust and permanently protected. So the thing to remember, excuse me, the thing to remember is that even if you or your loved one requires very expensive long-term care already, there is still an opportunity to protect somewhere between 1/3 and 2/3 of their remaining assets through this trust/annuity approach.
And that is why timing matters, because even though all of you understand the 5-year look back period now being a period of disclosure, not automatic denial of benefits, there's very big distinction between having it be a disclosure period rather than your outright, because a lot of people think, oh, I gave $10,000 to my children, or I gave 50,000 or whatever. It's dependent on how much money, as Tom explained through how Marguerite's calculation was that she only had to wait 21 months. And for her, it worked out because she really didn't need during those 21 months much more than the few hours a week. And then her needs changed dramatically after that, which was really helpful because she was able to get Medicaid benefits to cover as her increasing needs needed the home care benefits. So time matters. And so often people will say, well, I am healthy. And many people are very fortunate that they get through the 5-year look back period, in which case that matters. Mm-hmm. Now, Tom had also mentioned the criteria for Medicaid having an income threshold. And this is important too, because we often will have people come in and say, oh, there's no way that I can get Medicaid or my spouse can get Medicaid. We're starting home care. There's no way. We've just heard that he has way too much money. He's a school educator, retired, and gets $4,800 a month. Well, our client, Brian, is a typical scenario. He was a retired school teacher through the state of Connecticut. His income was something, I think it was about $4,800 a month, which we were thrilled for him. That's great. But he wanted to be able to qualify for home care benefits through Medicaid. And he thought, I'm probably out of luck, right?
Mm-hmm. So the income cap for the Medicaid home care program is around $2,300 a month. If you're over that, you're simply denied. But there is one way to cure that, and it's called a pooled trust, P-O-O-L-E-D. Under federal law, every state operates a pooled trust administered by a not-for-profit entity. And the way it works is you take your excess income and you contribute it to the trust every month. So let's say your income is $3,300 a month and you're over income by $1,000. Each month, this trust in Connecticut is administered by Plan of Connecticut. You can look at their website and you can see this is what they do. Each month you would send Plan a check for $1,000, but you would also send them household bills for them to pay with that money. So even though you're sending them $1,000, you're effectively getting it back because they're going to pay some of your bills for you. And that can include mortgage, taxes, homeowners insurance, rent. It can pay for some of your home care if you have some that you're privately paying for. It can pay for your credit card bill, utilities, just about anything. And so all you're doing is bouncing your money off of this trust every month and getting it back and using it for your bills. It's a little like money laundering, but legal. And it works every time. So why not?
Pretty powerful.
Very powerful.
We've actually seen people be able to stay at home because of this pool trust. Mm-hmm. Because as I had mentioned before with the Irrevocable Trust, it enables you to have that extra pot of money, because we know how expensive it is to live at home. That has nothing to do with home care. It just has to do with, how do I afford the other bills? Because if you do the straightforward apply for Medicaid, not setting money aside, either through an irrevocable trust and or a pool trust, how do you afford just the things that you need to afford? And
right,
so,
life on Medicaid is pretty miserable unless you have protected some of your resources in advance. And then you have a private pot to draw from to supplement whatever Medicaid is paying for you to really enhance your quality of life and most importantly, to preserve your options so that you don't have to be in a nursing home if you don't want to. You can afford to be in assisted living if that's appropriate, or you can afford to stay in your own home if that's feasible. The point is it would be financially feasible. And so if your condition allows it, well, then your finances allow it.
That's the reason that we tell people to make their own individualized plan about what are their goals. And you can't ask really anyone else but yourself what your goals are and how you want to age. And the reason that's important is because if your goal is to stay at home, which a majority of people want socialization, so they consider assisted living. I don't think we've ever had anyone come in and say, I want to go to a nursing home unless their medical needs are very complicated and they need that, but that's not really the plan at this point. So that's why it is important to be able to have some funds available to do all sorts of things. I mean, we've had clients who have MS and they really, really benefit from having private physical therapy or massage or things that create a better quality of life that enable them to have less pain and less suffering. And so if you don't have any funds available, either through the Irrevocable Trust and or a pool trust from saving your income, those things just simply aren't available to you. We're just going to briefly speak about another benefit where an irrevocable trust has been used. It's a powerful one for those of you who are veterans and spouses of veterans. Tom's just going to quickly summarize that benefit. We have more information on our website. We encourage you to look into it if you are a veteran, because it's a very powerful way to increase income, which can in turn then help you pay for your home care or assisted living.
So just real quick so that you're aware of it, if you or a loved one are a wartime veteran or a surviving spouse of a wartime veteran, even if you didn't serve in the combat theater, even if you were stationed domestically, and if you were discharged other than dishonorably, and if you currently need assistance with your activities of daily living, your ADLs, then you can qualify financially for a pension known as aid and attendance, which is really intended to be income replacement for non-service connected disability, usually the infirmities of old age. And the way it works is there's an asset test, there's an income test, there's a transfer of asset test, or in other words, look back period, under this program as well. So everything that we've talked about so far with regard to Medicaid can apply equally well with regard to qualifying for VA aid and attendance. So it all sort of works hand in hand. Just be aware that the program exists, and it can provide income of over $1,900 a month to a veteran, or over $2,300 a month for a couple, or over $1,200 a month for a surviving spouse. And that can go a long way in helping to pay for whatever form of care you most prefer.
So please pass that information on to any veterans or veterans' spouses, and we appreciate your service because it is a great benefit for people, and seen it work beautifully for someone who's living at home, needing home care, and or in assisted living. So please pass that information.
And for a lot of clients, we get both Medicaid and VA aid and attendance, and boy, is that powerful combination to help you protect your independent lifestyle.
As well as adding on the irrevocable trust, where you have that extra pool of money that is available for situations that once again can enhance your lifestyle. And that is what we feel strongly everyone should be focused on, about what is it that you want for how you want to structure it. So in keeping with that, this is not specifically related to trusts, but we always feel it's important that people be aware of this kind of tax deductibility planning. Our client, Tim, is very typical of a lot of our senior citizen clients. He just simply didn't have large amounts of income because he wasn't working. But he did have large amounts of medical bills, and his son actually was bringing this up. And we've had a lot of seniors and their children come to us telling us it was, well, Tim only has this amount of income, but look at all of the medical bills that he has. Is there anything to really maximize that tax deductibility planning?
So usually the person who's receiving the long-term care is retired, not receiving all that much taxable income. And so the medical expense deduction, or the deduction of expenses from long-term care, most of that is wasted. And so what we see some families do is shift bills to another family member, so that the family member who's in the best position to enjoy that deduction can do so to the full extent of the deduction. And so think of this situation: someone has established the irrevocable trust that we're talking about. Money goes into the trust, and after you need long-term care, the trust is distributing funds to one of your children, who then is giving the money back to you so that you can pay the provider. Well, if you do, then you're getting the medical expense deduction, but you can't use it. So what if you put money in the trust and then the trust distributes money to one of your kids, and then rather than the kid giving the money back to you, what if the kid pays the provider directly? Well, then that child, if those payments exceed 50% of your total support for that tax year, can claim you as a dependent on his or her 1040 and deduct all of your deductible medical expenses plus his or her own to the extent that they exceed 10% of his adjusted gross income. So let's say you have a child with an adjusted gross income of 150,000 and your medical expenses total 100 grand a year. That child can deduct everything that exceeds 15,000. So you just handed your child an $85,000 medical expense deduction year after year. And that child, if he has an $85,000 deduction that he didn't used to have, he's going to save $20,000 to $30,000 in income tax. And he can give that money back to you at no cost to himself so that you can pay for additional care to help forestall your need to financially to move into a nursing home. So for every year that you do this, you've increased your purchasing power by 2 to 4 months worth of care that you otherwise would not have been able to pay for at no cost to anyone in your family. It's just another tool in combination with everything we've discussed so far that allows you to reduce your expense on long-term care, which naturally helps you sustain your lifestyle, whatever you choose it to be.
So it's pretty neat to consider the options. You know, we've talked a lot about all the different trusts today, the Irrevocable Living Trust, the Support and Special Needs Trusts, the Retirement Fund Trusts, the Pet Trusts, and the Irrevocable Trust, and the Pooled Trust for the income issue if you're on Medicaid. So I'm sure your head is spinning about how these trusts are used, and we hope that through these examples, we've given a little bit more opportunity for you to think through how they are used. One other thing to consider, and this has also, it's just a very side issue on trust that we just feel is our responsibility as attorneys to advise and suggest that you have proper documentation for what it is you want to do. And we've seen countless clients. If you remember last week, it was our client Ron, and then it was the client Bernard the week before. So Ron had a power of attorney prepared by his family lawyer, family meaning he had used him for real estate closings and other miscellaneous errands. And Bernard came to us a couple weeks ago and he went online and had a power of attorney drawn. And everyone proudly brought these documents to us. But what was the result?
The result was that they both actually needed new powers of attorney. Everything we've talked about today requires very specific powers in a power of attorney. And if you don't think that matters, imagine a date in the future when you or your loved one is no longer able to manage his or her affairs. Then you need a power of attorney to be able to accomplish any of what we've talked about, or you simply won't be able to protect that loved one's assets and income, and it will all go bye-bye. A power of attorney is necessary for all of that. And as I mentioned, there are certain very specific powers that have to be written into the power of attorney, and those powers are normally not found in most power of attorney forms. The published forms that we've seen, even the forms that most Connecticut attorneys use, simply do not contain the powers that are necessary to move assets around in the fashion that we've described, or to establish trusts and fund them to the extent that we've described. Those actions are very specific in the law. And if your power of attorney doesn't include those powers, then you can't do what we've talked about. We can go to probate court and have a conservator appointed and ask the court's permission to do the things that we want to do. And we actually have very good luck with that. but it's not the kind of thing you want to plan for. It's expensive, it's public, you got a room full of lawyers. It's not the way to plan. I mean, the power of attorney is the least expensive legal document known to the Western world. And so it really behooves you to have a power of attorney prepared and have it done properly so that all of these elder law issues and estate planning issues are incorporated into that, and it can be used for everything that you might ever need it to be used for.
And in addition to that, you should also have a living will and a designation of a healthcare representative. And that is a different form than the power of attorney, because those are non-financial matters regarding health and personal needs. So we like to distinguish that having a power of attorney done with the specific language that Tom just had mentioned is only part of the puzzle. We want to make sure that you have everything you need to give you a comprehensive, holistic plan, and having a designation of a healthcare representative, which is the person who can speak to the doctor, as well as the living will, which designates your end of life wishes, is an important part of your package that you should have. So we're going to open up now to questions. We appreciate so much you spending this past a little more than an hour with us, and look forward to hearing what questions you may have regarding anything and everything that we've just talked about. So please unmute yourself.
I have a question with respect to the, can you hear me okay?
Yes, thank you. Hello.
With respect to the tax deduction planning and the scenario where the child pays your expenses, medical expenses, and takes a deduction, and then gives back to the parent, for instance, you know, what they've managed to save themselves. What is the nature of that money when it comes back to the parent? Is it a gift, or is it income, or what?
When it's returned to the parent, it would be a gift. And so the issue is how much per year.
Okay.
If it's below 15,000, then nothing. If it's more than 15,000, it has to be reported, or 30,000 if it's a couple. But even so, even if it has to be reported, as long as it doesn't exceed 7.1 million, then no gift tax will be paid.
Or it can be used to pay for more home care.
Well, once it's back in the hands of the parent, sure.
Because the whole goal is to be able to have these funds available to cover whatever comes your way. So it's creating a larger fund.
Now, it doesn't actually have to be returned to the parent's bank account. Let's say your son is doing this, he can just continue to pay for your care directly to the provider, because none of that is a reportable gift. If he pays for your college tuition or your medical expenses, none of that is a reportable gift. So he can just pay for more care than he otherwise would have. And as long as it's being tracked, then he can make sure that he's not dipping into his own money to pay for your care. And by the way, upon your death, he can redistribute among himself and your other children, depending on whatever net benefit he has received that maybe wasn't given back to you. So that can all be sorted out.
Right. The key is that you maximize the tax deductibility of the medical expense, because so many people are losing that because their incomes are too low to maximize that. So we like to drive that point home to make sure that people know that that's an option, because it's an added benefit that some people just every year lose. It's unfortunate. So good question. Thank you. Anyone else have any questions? We're going to be during a test on trust, so.
I do have another question if nobody else has one right now, and that's regarding the IRA beneficiary trusts. One of the things that you can do with a regular IRA or that kind of vehicle is you can state what percentage, for instance, of the value of the IRA gets paid to, you know, each individual child, let's say, okay? Mm-hmm. So this one will get only this much and this one will get a percentage. If you're doing that kind of thing, do you have to have a trust for each of those individuals, or is it one trust for that IRA that states how the distribution is going to be?
The trust agreement always contains those sorts of instructions. Mm-hmm. You want everything to go to your 3 children equally, well, that's what it says. If you want it to go to your 3 children unequally, then it provides the percentages that you choose. Mm-hmm. And either way, it says that the share being held for each beneficiary will be kept and administered in a separate sub-trust, so that each child has the ability to receive their distributions or suspend their distributions depending on what's going on in his or her life without affecting the others at all. Okay, thank you.
It provides that extra layer of protection, whereas, you know, not everyone has different situations.
It's really customizable, and everyone we write is different.
Yeah. Thank you.
Good question. Mm-hmm. Great. Any other questions?
They're all asleep.
I know. I guess you get the show. You get to have the stage here. Well, we're glad that.
A question?
Oh, we have a taker.
All right.
Okay.
Oh, well, look at you. If we have a trust, and instead of building into it, per stirpes, this, that, so on, if we just say each one will get what's on the distribution list. So we have a separate sheet of paper with names of whoever we wish to have on their kids and maybe friends and so on. And the amounts of money that we want to give them, fixed amount of money, not and the trust is, what is it called? You have to get it notarized and all, but this sheet, I was given to understand a sheet like that would not have to be notarized, could be changed every few months as far as adding, taking away names or amounts of money. Is that doable and legal and wise or unwise?
Well, first of all, a trust agreement doesn't have to be notarized in the state of Connecticut, but we usually do that anyway.
Okay. Oh.
Any schedule that's intended to be part of the trust agreement should be made part of the trust agreement.
Yep.
I mean, it really should be stapled and bound in the agreement so that it's very clear what the intention plan is. Otherwise, upon your death, every family member and person you've ever met is going to show up with their own list.
You can imagine the chaos of that one.
Yeah, it really should be as secure as possible. Now, it can be, you know, these things can be amended anytime you like. The retirement plan trust is a revocable trust, which means it's also infinitely amendable. All of the revocable trusts that we've talked about today are amendable, and it's very easy to do. So, I mean, most people don't have a new list every 6 months, but, you know, from time to time, things change and people can give us a call, and it's a 1 to 2 page amendment. It's not a big deal. And then that becomes part of your trust. You have your initial trust plus your First Amendment or Second Amendment or 18th Amendment or whatever.
So that if we adjusted the list, is that considered an amendment then and has to kind of go through a attorney, or is it just something we can take out the old one, put in the new one with our signatures and date, and that's what we'll control?
No, I would say that's not adequate. That is, that carries the potential of litigation with it. Any amendment to your trust agreement should really be done with legal formality, and it should very specifically state that it's an amendment to your trust agreement. It should refer to the section it's amending. There's a right way to do it so that there's nothing other than the interpretation you intend.
Because you wouldn't want anybody to contest that.
The definition of legalese is perfect English, because anything you read in an 18-page trust agreement, I assure you, there is no shorter way to say it. You want to change something about your trust agreement, whether it be the distribution or your selection of trustees or whatever, it really should be done in a proper formality. Just like if you have a will and you're changing your will, that should be done through a codicil, which is the way to change a will. Otherwise, you're inviting litigation, and then everybody you wanted to benefit from all your hard work, they're going to have a chunk taken out of that, paying for legal fees and having the whole thing delayed by a year or 2 or 3.
Right, defeats the purpose.
Yeah.
You know, if you want clarity and you want something to honor your wishes,
yeah,
you wanted to make sure it reflects that.
Yeah.
Okay, thank you.
Yeah.
Good question, thank you. Anyone else want to jump
in? Does having the trust do away with the need for a will?
It makes the will moot, but we still do one. So if you're doing either a revocable or an irrevocable trust, and the intent is to bypass probate, if you fully fund the trust, if you put everything you own into the trust, then upon your death, no one's going to read your will. There's no need. Nothing's being probated. Right. But it's standard practice to also do a will anytime we're doing a trust. And in that case, the will takes on the form that's nicknamed a pour-over will. And what it says is basically, I have a trust, and if I forgot to put something in it while I was alive, do it now. Pour it into the trust, so to speak, so that everything flows through the trust as one vessel. That doesn't mean it's okay to leave assets outside your trust. If you do, they have to be probated. But the thought is, well, what if 5 years after we meet a client, they go out and they buy a new car and they forget to take title in their trust? Well, then they leave behind a car that has to be probated. So it's safer to have both, even though the intent is that everything would pass under the trust.
Right, we've had situations.
It's belts and suspenders.
Bank accounts, oh, forgot that one, or yeah. So things happen. And that way you're at least covered in the event, like a situation of a car or what have you.
Right, thank you.
Question. Anyone else want to jump in? The water's fine. Going once, going twice.
Well, Tom and Michele, thank you so much. We have really, you did give us a lot to think about. And
right, we should open this up, Miranda, in about 6 days. You know, oh, I thought of that.
Yes, the questions for after. You really, I have to say, through this presentation and the last presentation, you have just given us an abundance of information, so much to think about. And I really can't thank you enough. You've been so generous with your time and everything that all your expertise as well. So thank you. And I want to thank all of you for coming as well, and your wonderful questions and for your interest in all of this. This is really important for all of us to know about. So thank you.
Well, we appreciate the opportunity, and it's always nice getting to know new people.
That's right. And we want all of you to make really good decisions based on what you want, not when somebody else tells you you need.
And if you think of another question in the days ahead, give us a call. That's fine.
Right. On our outline, we have our website. You can email us through that. We're happy to, we invite questions because that's what triggers more thought and discussion over a good plan, not something you're putting together because you're in a crisis. So we appreciate it so much. We hope everyone stays well and gets to enjoy the upcoming beautiful season in New England. And we hope that this year is a good one.
Yes.
Thank you very much. God bless you.
Thank you very, very much.
Thank you.
Be well, everyone.